Good afternoon. Thank you for joining us on this episode of Legal Learning, the series that keeps you informed and empowered. In today's episode, we're zeroing in on recent changes to Florida's landlord tenant laws. What's new? What's shifting? And most importantly, how these changes may affect you. Guiding us through it all are Paralegal Richard Rudolph and attorney Jeff Hittleman from the senior unit at Coast to Coast Legal Aid of South Florida. From changes to how notices can be served to new rules on flood disclosure, they'll break down what you need to know. Let's get started, Rick and Jeff. Over to you.
Disclaimer. This presentation is not intended to provide specific legal advice, information. Current as of July 2nd, 2025. The views and opinions expressed in this episode are those of the speakers and do not necessarily reflect the official policy or position of the office. This PowerPoint may not be reproduced, distributed, copied, or cited, in whole or in part, without Coast to Coast Legal Aid of South Florida's written permission. For more information, please visit our website at www.coasttocoastlegalaid.org or call 954-736-2400.
Good afternoon, and thank you for joining us on Legal Learning. Today, we have a special guest, our longtime paralegals here at Coast to Coast Legal Aid, Richard Rudolph. Some new landlord tenant laws took effect July 1st, 2025. We're going to talk about some of these changes and what to expect if you're a renter. Rick, let's talk about the first one. Rick, let's talk about email notices. This is a change from how it's always been done. Tell us about kind of what's can be different, and we can look at how this might play out overall.
All right. Well, as of now, July 1st, the new laws say that landlords and tenants could go on and communicate by email as far as giving notices, different notices that are required. And so these notices are strictly voluntary that you could sign up for to get notices by email. If you are a tenant, you could agree to receive notices by email, or you could not agree to it. What the law is trying to go ahead and bring everybody into the 21st century by doing everything electronically. So in a lot of the notices, the important notices like 3-day notices, which are notices that you would get if you owe rent, or 7-day notices, that's where a landlord may want you to correct a condition that's going on in your unit, or you may want to send a landlord a notice saying, hey, there's something wrong in my unit, or it could be that they're going to terminate your lease, or it could involve security deposits. It could involve all kinds of different things that landlords used to have to just hand you notice or mail you notices to. Now the law allows the landlords and tenants to communicate by email.
Exactly, and we were talking about it this week when the law changed, and just trying to think about the pros and cons, because as you pointed out, Rick, this is optional, and to be included to do this, the tenant and the landlord would both have to sign an addendum to the lease. I know that when I would get my lease, the landlord would put like 40 pages in front of me, and I would just fly through signing them. So it's a good reminder to go through and look at each page and read what you're signing. Because to opt into this email, doing notices by email, you have to agree to it. And we were kicking around the pros and cons of this, Rick. What were you thinking in terms of some of the pros and cons for landlords and tenants?
The very interesting thing that everyone needs to be aware of is that these notices, I think, they go ahead and they make things quicker. However, pros and cons. Yes, it's going to be faster to communicate, but the downside to it is, say, for instance, you legitimately owe rent. And on the second day of the month, if your rent is due on the first, on the second day of the month, theoretically, your landlord could just go ahead and push a button and send you a 3-day notice. And that's considered delivered to you. Whereas before, the landlord would have to go ahead and come over to your house and post a notice on your door or mail it to you. So for those people that are behind on rent legitimately, but they need like that extra 1 or 2 days, by agreeing to emails, you may be giving up that extra 1 or 2 days that you need to go ahead and get the money together. So I definitely think for tenants, I think that the fewer mail days and receiving information, stuff like that, I think that's not good for the tenant.
And we've seen cases like that where having that extra time where it takes more days, if notice is being mailed, posted, having that extra time to gather the rent money, come up with a solution can really make a difference in the case. So that's a great thing to think about. Another piece that that you pointed out, Rick, tenants can opt out. So if this is something you as the tenant sounds interesting, you want to try it, and then down the road you decide that it's not working. The new statute does say that you can opt out, so that is an option that you'll have.
It's definitely gives you the option to opt in and opt out. So that's a good thing, because once you do, it doesn't mean that you're permanently committed, but you have to follow directions if you want to opt out. Make sure if you do agree to getting emails and you want to opt out of it, that you keep a copy of notifying the landlord, hey, I want to go ahead and opt out of this. And you want to keep that in your records so that you could prove that you went ahead and opt out of the agreement to be notified by email. More important, though, is if you've already received the notice before you opt out, then you can't opt out that specific notice. You could only opt out notices subsequent to that.
Good point.
So
Very good.
yes. So that's interesting. And Jeff, I just want to back up on when you agree to this in the lease we talk about, and a lot of people get like 40-page leases and they just sign and this and that. The understanding of the law is that landlords can't just go ahead and pop this into the lease someplace where you're not going to be reading. It has to be a specific addendum to the lease, and it has to be in a very specific form. So it's not something that could sneak in there. It's something that you specifically would read, you would consent to it or not consent to it. So that's very important. They can't just sneak it into a lease. When I say them, obviously I'm talking about landlords.
Exactly. It should be a separate, clear addendum. Just another one of those good reminders. When you're signing your lease, take your time, read through everything, and you'll see exactly what you're agreeing to.
Yes.
Great point.
Very, very, very important.
Rick, anything else on email notices, or should we move on to some of the other topic changes? Landlord tenant.
This is a personal opinion. I don't like the idea of this for tenants, because I think that days, even a couple days here and there, makes a big difference as a tenant struggling to maintain their rent. So you want to try and use everything to your advantage legally. So if it means making that landlord actually come over in 2-3 days to give you that notice, that 2 or 3 days is going to make a big difference for someone who's struggling to get that rent together. So I'm not too sure I like this for tenants. My thought would be not to agree to it, but it's obviously everybody makes their own decision. That's my opinion.
Choice. You're right. Everyone's personal choice, but we've seen a lot of cases where there's a couple extra days that have helped solve it. So that's a great point. A couple other updates we want to talk about. One is the flood risk disclosure that will now apply to renters in Florida. Tell us a little bit more about this, Rick.
Well, now with the flood laws, you have to be notified if the place you're renting has been involved in a flood, or if there've been insurance claims made on flooding in the unit that you're going to be renting. That's very important because this also helps you decide if you want to go ahead and have renter's insurance when you're renting a place. So I think this is a great thing for tenants, knowing that, hey, I'm in a flood zone. I didn't even think about that before I decided to rent this place. So I think it's a good law for the tenants.
Exactly. And the statute's going to spell out exactly when the landlord has to disclose that there was a flood, and the procedure for how the landlord has to disclose that. So it's just more information that you're going to have as a tenant, which should be helpful when you're making that decision whether to rent a place.
So many people, it's sad to say, call up right after they move into a place and they say, I didn't know this, I didn't know that. So this is one additional disclosure that the landlord would have to give to tenants. So I think it's a great thing.
Helpful. And same, the protection expands to if a landlord doesn't disclose this and then a flood does occur, it'll give the tenant rights to move out and terminate the lease without penalty, and hopefully get some of their security deposit or prepaid rent back. So it provides a whole host of protections in
Yes.
flood situation. Last but not least, we wanted to talk about not necessarily a change in the law, but just a new trend that we're seeing in the landlord-tenant world. And that's this option where tenants can have rent payments reported to the credit reporting agencies. Rick, share a little bit more about that, what we've been seeing.
Yeah, from what we've been seeing, there are these different places that they're trying to say, hey, you could build your credit for $5 a month up to $35 a month. We could allow you to build your credit quicker. That's in summary what this is talking about. That $5 a month is $60 a year to build your credit.
Yep.
That's how I see that. By just paying your bills on time, I don't see this as making much of a difference, but it's just another way to get people to go ahead and focus on keeping the rent payments current and stuff, and where it would be specifically reported. I'm just not sure if I'd be wanting to throw away 60 or a couple $100 a year to improve my credit score. I'd rather just keep paying my bills on time, keep the extra money in my pocket.
Exactly. Yeah, this is really one to think through and read all the fine print before signing up for it, and make clear that this is the decision you want to make after weighing the pros and the cons.
And I hope it really helps a lot of people out there. And if ever anybody has any questions, they should always remember, call us up for advice. That's what we're here for. This is what we do. Even if you think the question is silly, call us up. If you have a legal issue, call us up.
Absolutely. Well said, Rick. Thank you so much for joining us on Legal Learning. Keep following us on our social media platforms and tune into our next episode. We'll keep sharing tips, knowledge, good resources to help you out. Hope you have a good afternoon.
Bye, everyone.
Thanks for joining us for today's episode of Legal Learning. We hope today's update on Florida's landlord tenant laws helps you better understand the rules and your rights. Also, a big thank you to Senior Law Unit Summer Interns April and Mansha for helping create the PowerPoint slides. To stay up to date on future episodes, make sure to follow us on social media. You can find Coast to Coast Legal Aid of South Florida on Facebook, Instagram, LinkedIn, and YouTube. Like, subscribe, and share, because legal knowledge is power, and it's better when we spread it. Until next time, stay informed and stay connected.